Welcome to Supreme Court Opinions. In this episode, you'll hear the court's opinion in Diaz v. United States. In this case, the court considered this issue. Under Federal Rule of Evidence 704B, may a governmental expert witness testify that couriers know they are carrying drugs and that drug trafficking organizations do not entrust large quantities of drugs to unknowing transporters to prove that the defendant knew she was carrying illegal drugs? The case was decided on June 20, 2024. The Supreme Court held that expert testimony that most people in a group have a particular mental state is not an opinion about the defendant and thus does not violate Federal Rule of Evidence 704B. Justice Clarence Thomas authored the 6-3 majority opinion of the court. Federal Rule of Evidence 704B is a narrow exception to the general admissibility of ultimate issue opinions established by Rule 704A. It only prohibits expert opinions about whether a specific defendant had a particular mental state that is an element of the crime or defense. It does not bar testimony about the mental states of people in general or groups that may include the defendant. Moreover, the language of Rule 704B, particularly the word about, supports the conclusion that the rule targets specific conclusions about a defendant's mental state, not just any testimony related to mental states. This interpretation is further supported by the context of Rule 704A, which allows opinions embracing ultimate issues, making Rule 704B a narrow exception to that broader rule. Justice Ketanji Brown Jackson authored a concurring opinion to emphasize that, as Congress designed it, Rule 704B is party agnostic. Justice Neil Gorsuch authored a dissenting opinion, in which Justices Sonia Sotomayor and Elena Kagan joined. Justice Gorsuch argued that the majority's interpretation allows prosecutors to put an expert on the stand to testify as to what most people like the defendant think when they commit a legally prescribed act and then merely convince the jury that the defendant is like most people and convict. The opinion is presented here in its entirety, but with citations omitted. If you appreciate this episode, please subscribe. Thank you. Justice Thomas delivered the opinion of the court. Federal Rule of Evidence 704B prohibits expert witnesses from stating opinions about whether the defendant did or did not have a mental state or condition that constitutes an element of the crime charged or of a defense. In this drug trafficking prosecution, petitioner argued that she lacked the mental state required to convict because she was unaware that drugs were concealed in her car when she drove it across the United States-Mexico border. At trial, the government's expert witness opined that most drug couriers know that they are transporting drugs. Because the expert witness did not state an opinion about whether petitioner herself had a particular mental state, we conclude that the testimony did not violate Rule 704B. We therefore affirm. In August 2020, Delilah Diaz, a United States citizen, attempted to enter the United States from Mexico. When Diaz drove into the port of entry, a Border Patrol officer asked her to roll down the car's rear driver's side window. Diaz responded that the window was manual, so the officer left his inspection booth and tried to roll down the window himself. The officer felt some resistance and then heard a crunch-like sound in the door. Aware from experience that car doors are a common hiding spot for contraband, the officer investigated further with a buster, a handheld tool that measures an object's density. After the buster detected an abnormal density in the doors, officers brought in a narcotics detection canine and sent the car through an X-ray machine. They discovered 56 packages of methamphetamine tucked inside the car's door panels and underneath the carpet in the trunk. The methamphetamine weighed just over 54 pounds and had an estimated retail value of $368,550. Diaz was arrested and, after waiving her Miranda rights, agreed to an interview. Diaz claimed that she had no idea drugs were hidden in the car. The officers, however, found her story hard to believe. Diaz explained that she was driving her boyfriend's car. Contradictorily, she also told officers that she had seen her boyfriend only 2-3 times tops, did not know his phone number, and did not know where he lived. Diaz's story grew even more dubious when officers questioned her about 2 cell phones discovered inside the car. She acknowledged that she owned one of the phones, but she maintained the other phone had been given to her by a friend, whom she would rather not identify. And she insisted that the phone was locked and that she did not have access to it. Diaz was charged with importing methamphetamine in violation of federal statutes. The charges required the government to prove that Diaz knowingly transported drugs. In response, Diaz asserted what is known colloquially as a blind mule defense. She argued that she did not know that there were drugs in the car. Before trial, the government gave notice that it would call Homeland Security Investigations Special Agent Andrew Flood as an expert witness. Agent Flood would testify about the common practices of Mexican drug trafficking organizations. Specifically, he planned to explain that drug traffickers generally do not entrust large quantities of drugs to people who are unaware they are transporting them. Diaz objected to Agent Flood's proffered testimony under Federal Rule of Evidence 704B. That rule provides that, in a criminal case, an expert witness must not state an opinion about whether the defendant did or did not have a mental state or condition that constitutes an element of the crime charged or of a defense. Diaz argued that if Agent Flood testified that drug traffickers never use unknowing couriers, that would be functionally equivalent to an opinion about whether Diaz knowingly transported drugs. The district court granted Diaz's motion in part and denied it in part. The court agreed with Diaz that Agent Flood could not testify in absolute terms about whether all couriers knowingly transport drugs, but, insofar as Agent Flood planned to testify only that most couriers know they are transporting drugs, the court concluded that his testimony was admissible. At trial, Agent Flood testified that in most circumstances, the driver knows they are hired to take the drugs from point A to point B. To use an unknowing courier, Agent Flood explained, would expose the drug trafficking organization to substantial risk. The organization could not guarantee where, if at all, the drugs would arrive. Even if the drugs reached the intended destination, the organization would then have to retrieve the drugs without detection. According to Agent Flood, drug trafficking organizations are often unwilling to take those chances with hundreds of thousands of dollars on the line. Agent Flood acknowledged on cross-examination that drug trafficking organizations sometimes use unknowing couriers. The jury found Diaz guilty, and the district court sentenced her to 84 months imprisonment. On appeal, Diaz again challenged Agent Flood's testimony under Rule 704B. The Court of Appeals held that Rule 704B prohibits only an explicit opinion on the defendant's state of mind. Because Agent Flood did not opine about whether Diaz knowingly transported methamphetamine, the court concluded that the testimony did not violate Rule 704B. We granted certiorari and now affirm. Federal Rule of Evidence 704 addresses opinions on an ultimate issue. Rule 704A sets out a general rule that an opinion is not objectionable just because it embraces an ultimate issue. Rule 704B adds one caveat. Exception: in a criminal case, an expert witness must not state an opinion about whether the defendant did or did not have a mental state or condition that constitutes an element of the crime charged or of a defense. Those matters are for the trier of fact alone. Rule 704 departed from the once prevailing common law practice. Prior to Rule 704, many states applied what was known as the ultimate issue rule. That rule categorically barred witnesses from stating their conclusions on any ultimate issue, i.e., issues that the jury must resolve to decide the case. For example, in a medical malpractice suit, an ultimate issue may be whether the plaintiff's condition resulted solely from malpractice. In a murder case, by way of comparison, an ultimate issue may be who fired the gun that killed the victim. Under the common law rule, a witness could not provide his answer to those ultimate issues. Witnesses remained free, however, to offer related testimony, even testimony that directly helped the jury resolve an ultimate issue. The logic underpinning the ultimate issue rule was that it prevented witnesses from taking over the jury's role. The rule's stated justification was to exclude testimony that usurps the function or invades the province of the jury. If a witness gave an opinion covering the very question which was to be settled by the jury, some feared that the jury would be left with no other duty but that of recording the finding of the witness. Although the ultimate issue rule's exact origins are unclear, legal scholars agree that several states had adopted it by the late 1800s. The rule was short-lived though, and courts and commentators came to doubt its propriety within a matter of decades. Many rejected the idea that ultimate issue testimony usurps the jury's role, since a witness's credibility and the soundness of his judgment always remain for the jury's determination. Others labeled the rule impracticable and misconceived because it excluded the most necessary testimony on issues where the jury should have help if it is needed. By the 1940s, a trend had emerged to abandon the rule altogether. It soon became unclear whether, and to what extent, the ultimate issue rule carried any force. Rule 704 made clear that the ultimate issue rule did not apply in federal courts. When Rule 704 was originally adopted in 1975, it had no exceptions. All ultimate issue opinions were permitted. About 9 years later, in the wake of the John Hinckley Jr. trial, Congress created the exception now found in Rule 704B. On March 30, 1981, Hinckley attempted to assassinate President Ronald Reagan, shooting and wounding the president and 3 other men. At his criminal trial, Hinckley claimed that he was insane. Both the prosecution and defense offered competing expert opinions on the ultimate issue of Hinckley's sanity. To the surprise of many, Hinckley was found not guilty by reason of insanity. Congress adopted Rule 704B shortly thereafter to carve out an exception to Rule 704's blanket rule admitting ultimate issue opinions. As Rule 704B now reads, in a criminal case, an expert witness must not state an opinion about whether the defendant did or did not have a mental state or condition that constitutes an element of the crime charged or of a defense. By its terms, Rule 704B's exception covers a narrow set of opinions. The exception does not apply in civil cases or affect lay witness testimony, and it exclusively addresses mental states and conditions that are elements of the crime charged or of a defense. Rule 704B thus prescribes only expert opinions in a criminal case that are about a particular person, the defendant, and a particular ultimate issue, whether the defendant has a mental state or condition that is an element of the crime charged or of a defense. Rule 704B applies only to opinions about the defendant. Because Agent Flood did not express an opinion about whether Diaz herself knowingly transported methamphetamine, his testimony did not violate Rule 704B. Agent Flood instead testified about the knowledge of most drug couriers. Specifically, he explained that in most circumstances, the driver knows they are hired to take the drugs from point A to point B. That opinion does not necessarily describe Diaz's mental state. After all, Diaz may or may not be like most drug couriers. Diaz herself made this point at trial. She argued that another person, an alleged boyfriend, had deceived her into carrying the drugs. During opening statements, Diaz's counsel explained that Diaz met her boyfriend while she was brokenhearted over the death of her mother and recovering from a debilitating back injury. Diaz's boyfriend took advantage of those circumstances to lure Diaz to Mexico. As her counsel described it, the boyfriend then loaned Diaz a car that was secretly loaded with drugs for her drive back to the United States. Diaz supported that story during her case in chief. She presented an automobile mechanics expert who testified that there was no way for someone to suspect or know that there were drugs hidden within the car. Diaz also challenged the government's contrary theory. On cross-examination, Diaz's counsel highlighted that Agent Flood was not involved in Diaz's case and that the government itself was aware of cases involving unknowing couriers. The jury was thus well aware that unknowing couriers exist and that there was evidence to suggest Diaz could be one of them. It simply concluded that the evidence as a whole pointed to a different conclusion, that Diaz knowingly transported the drugs. The jury alone drew that conclusion. While Agent Flood provided evidence to support one theory, his testimony was just that, evidence for the jury to consider or reject when deciding whether Diaz in fact knew about the drugs in her car. Because Agent Flood did not give an opinion about whether Diaz herself did or did not have a mental state or condition that constitutes an element of the crime charged or of a defense, his testimony did not violate Rule 704B. Diaz's counterarguments, echoed by the dissent, are not persuasive. Diaz and the dissent argue that Agent Flood functionally stated an opinion about whether Diaz knowingly transported drugs when he opined that couriers generally transport drugs knowingly. That argument mistakenly conflates an opinion about most couriers with one about all couriers. A hypothetical helps explain why this distinction matters under Rule 704B. Take for example an expert who testifies at an arson trial that all people in the defendant's shoes set fires maliciously, the mental state required for common law arson. Although the expert never spoke the defendant's name, the expert nonetheless violated Rule 704B. That is because the expert concluded that the defendant was part of a group of people that all have a particular mental state. The phrase "all people in the defendant's shoes" includes, of course, the defendant himself. So, when the expert testified that all people in the defendant's shoes always set fires with malicious intent, the expert also opined that the defendant had that mental state. The expert thus stated an opinion on the defendant's mental state, an ultimate issue reserved for the jury, in violation of Rule 704B. Here, by contrast, Agent Flood asserted that Diaz was part of a group of persons that may or may not have a particular mental state. Of all drug couriers, a group that includes Diaz, he opined that the majority knowingly transport drugs. The jury was then left to decide, is Diaz like the majority of couriers? Or, is Diaz one of the less numerous but still existent couriers who unwittingly transport drugs? The ultimate issue of Diaz's mental state was left to the jury's judgment. As a result, Agent Flood's testimony did not violate Rule 704B. Diaz and the dissent next zero in on the word "about" in Rule 704B. They rely on dictionary definitions of "about" to argue that Rule 704B's prohibition includes all testimony that concerns or is in reference to whether the defendant possessed a particular state of mind. But, a word's meaning is informed by its surrounding context. A crucial part of that context is the other words in the sentence. The words surrounding "about" make clear that Rule 704B addresses a far narrower category of testimony than Diaz and the dissent posit. To begin, the rule targets opinions. In other words, the testimony must be more than a general reference, and it must reach a particular conclusion. Moreover, the rule does not preclude testimony about mental state ultimate issues in the abstract. Instead, it targets conclusions about whether a certain fact is true, the defendant did or did not have a mental state or condition. The language as a whole thus conveys that Rule 704B is limited to conclusions as to the defendant's mental state. Rule 704A further confirms the narrow scope of testimony prohibited by Rule 704B. Recall that the original ultimate issue rule excluded opinions on the ultimate issue itself. Rule 704A abolished that practice by permitting testimony that embraces an ultimate issue. Because Rule 704B is an exception to Rule 704A, it can only be understood to cover a subset of the testimony that Rule 704A expressly allows. In short, since Rule 704A permits opinion testimony that includes ultimate issues, Rule 704B must exclude only a subset of those same opinions. The reading offered by Diaz and the dissent would have the exception swallow the rule. If Rule 704B were as broad as they suggest, it would be a standalone prohibition broader than Rule 704A or even the original ultimate issue rule. Even though the ultimate issue rule and Rule 704A address opinions that include the ultimate issue itself, Rule 704B would prohibit all opinions even related to the ultimate issue of a defendant's mental state. Rule 704's text does not support such an expansion. The rule as a whole makes clear that an opinion is about the ultimate issue of the defendant's mental state only if it includes a conclusion on that precise topic, not merely if it concerns or refers to that topic. An expert's conclusion that most people in a group have a particular mental state is not an opinion about the defendant and thus does not violate Rule 704B. Accordingly, the judgment of the Court of Appeals is affirmed. It is so ordered. Justice Jackson, concurring. I join the court's opinion in full. Federal Rule of Evidence 704B forbids expert witnesses in criminal trials from offering their opinion about whether the defendant did or did not have a mental state or condition that constitutes an element of the crime charged or of a defense. As the court explains, Rule 704B is narrow. Against the backdrop of federal rules that authorize admission of all relevant evidence, it prohibits only expert opinions about a particular person, the defendant, and a particular ultimate issue, whether the defendant has a mental state or condition that is an element of the crime charged or of a defense. But, as narrow as it is, Rule 704B strikes a very important balance. It allows for potentially highly probative expert testimony to be submitted to the jury, while leaving the ultimate issue of the defendant's mental state to the jury's judgment. I write separately to emphasize that, as Congress designed it, Rule 704B is party agnostic. Neither the government nor the defense can call an expert to offer her opinion about whether the defendant had or did not have a particular mental state at the time of the offense. But a corollary is also true. Both the government and the defense are permitted, consistent with Rule 704B, to elicit expert testimony on the likelihood that the defendant had a particular mental state, based on the defendant's membership in a particular group. Indeed, the type of mental state evidence that Rule 704B permits can prove essential not only for prosecutors, but for defendants as well. This very case illustrates the significance of mental state evidence to both parties in a criminal trial. The government expert opined, based on his almost 30 years of experience as a special agent, that, in most circumstances, drug couriers know that they are transporting drugs. Diaz challenged this testimony, and today, the court holds that the government did not violate Rule 704B. Notably, however, the government was not the only party that relied on this type of mental state evidence during the trial. Diaz called an automobile specialist who testified that a driver of her particular car would almost certainly not know that it contained drugs. That type of evidence is permissible under the interpretation of Rule 704B the court adopts today. Moreover, as the dissent observes, Diaz might have opted to introduce other types of expert evidence related to the mental state element. For example, Diaz could have offered expert testimony on the prevalence and characteristics of unknowing drug couriers. For the reasons described in today's opinion, none of that evidence would deprive the jury of its ability to decide the last link in the inferential chain, whether Diaz herself had the requisite mens rea. But at the same time, having all of this testimony might have helped the jury determine whether the government had met, or failed to meet, its burden of proving that Diaz knew of the drugs found in her car. Thus, far from disserving our criminal justice system, the type of mental state evidence that Rule 704B permits can be of critical assistance to lay fact-finders tasked with determining a defendant's mental state as an element of the alleged crime, or defense. Other examples provide further proof. Consider expert evidence on mental health conditions. Congress crafted Rule 704B to prohibit experts from opining on a particular defendant's mental state at the time of an offense. But it did not preclude experts from contextualizing a defendant's mental health condition, including by explaining the likelihood that those with a particular condition would have a particular mental state. For example, as Diaz acknowledges, the interpretation of Rule 704B the court adopts today allows psychiatrists who testify as experts to tell the jury that when people with schizophrenia as severe as a defendant's commit acts of violence, it is generally because they do not appreciate the wrongfulness of their conduct. That type of expert evidence would not result in the spectacle of dueling experts on the defendant's actual mental state, which Congress sought to eliminate when it codified Rule 704B. Instead, given the biases, stereotypes, and uneven knowledge that many people have about mental health conditions, such expert evidence could help jurors better understand a defendant's condition and thereby call into question a mens rea that might otherwise be too easily assumed. Or consider defendants who have been subject to domestic abuse. A number of myths and misconceptions about battered woman syndrome victims affect our criminal justice system, and it is clear that those mistaken views affect jurors. Rule 704B allows experts to testify about the typical mental states of those with battered woman syndrome, helping jurors to better understand how those experiencing it respond to aggression or react to violence. Such evidence can play a pivotal role in a defendant's attempts both to disprove the mens rea in a number of serious crimes and to support a range of defenses, including duress and self-defense. All that said, I fully acknowledge that there are serious and well-known risks of over-reliance on expert testimony, risks that are especially acute in criminal trials, but there are also safeguards outside of Rule 704B to prevent the misuse of expert testimony. Nothing in the court's opinion today should be read to displace those important checks and limitations. This means, of course, that when faced with flawed or faulty testimony concerning the mental states of groups or categories of individuals, parties can utilize the traditional tools in a lawyer's toolkit, like vigorous cross-examination and careful refutation in closing argument. Parties can also seek to employ other rules of evidence that might require exclusion, those that guard against irrelevant or unduly prejudicial testimony, for example, and those that require courts to bar unqualified or overreaching experts. District court judges also have a role to play. They should be protective of Congress's intent to preserve the jury's core duty, by providing specific admonitions and instructions when expert testimony about a relevant mental state is introduced. With this understanding of both the important uses and the potential misuses of Rule 704B, I join the court's opinion. Justice Gorsuch, with whom Justice Sotomayor and Justice Kagan join, dissenting. Federal Rule of Evidence 704B prohibits an expert witness from offering an opinion about whether the defendant did or did not have the mental state needed to convict her of a crime. Those matters, the rule instructs, are for the trier of fact alone. Following the government's lead, the court today carves a new path around that command. There's no Rule 704B problem, the court holds, as long as the government's expert limits himself to testifying that most people like the defendant have the mental state required to secure a conviction. The upshot? The government comes away with a powerful new tool in its pocket. Prosecutors can now put an expert on the stand, someone who apparently has the convenient ability to read minds, and let him hold forth on what most people like the defendant think when they commit a legally prescribed act. Then, the government need do no more than urge the jury to find that the defendant is like most people and convict. What authority exists for allowing that kind of charade in federal criminal trials is anybody's guess, but certainly it cannot be found in Rule 704. Delilah Diaz's conviction for drug trafficking turned on her state of mind. In that, hers was an everyday case. Often in our criminal justice system, the difference between freedom and years in prison turns on just that question. Perhaps it has always been so. The government's duty to prove that the defendant it seeks to convict had a culpable state of mind when committing a proscribed act is as ancient as it is fundamental to our system of justice. At common law, a complete crime generally required both a will, or mens rea, and an act, or actus reus. That same view took deep and early root in American soil where, to this day, a crime ordinarily arises only from the concurrence of an evil-meaning mind with an evil-doing hand. So ingrained is this view that courts have long presumed criminal statutes demand proof of mens rea even when they are silent on the subject. Why does our law generally insist not just on a bad act but also a culpable state of mind? A significant part of it has to do with respect for the individual and his liberty in a free society. Criminal liability imports a condemnation, the gravest we, as a nation, permit ourselves to make. Of course, our law recognizes gradations of mens rea, ranging from purpose and knowledge to recklessness and negligence. But to subject a presumptively free individual to serious punishments for acts undertaken without proof of any of that would be the badge of tyranny, the plainest illustration of injustice. The principle that an injury can amount to a crime only when inflicted with some accompanying mens rea is, we have said, as universal and persistent in mature systems of law as belief in freedom of the human will and a consequent ability and duty of the normal individual to choose between good and evil. At trial, deciding whether a criminal defendant acted with a culpable mental state is a job for the jury. No matter how clear the proof or incontrovertible the inference, the question whether a defendant possessed a culpable mens rea must always be submitted to the jury. Always, too, the government bears the burden of proving the requisite mens rea. Never, we have held, may the government seek to shift the burden of proof to the defendant. Nor may a court instruct a jury that it must presume a defendant's state of mind from any particular set of facts, no matter how compelling they may be. Reflecting the centrality of mens rea to criminal punishment and the jury's role in finding it, Rule 704B of the Federal Rules of Evidence provides that, in a criminal case, an expert witness must not state an opinion about whether the defendant did or did not have a mental state or condition that constitutes an element of the crime charged or of a defense. As the rule continues, those matters are for the trier of fact alone. By all accounts, the immediate impetus for the rule was the trial of John Hinckley for the attempted assassination of President Ronald Reagan. In that case, experts didn't just offer competing views on whether Hinckley suffered from a medically diagnosable mental illness. They went much further. The trial descended into a battle between experts who claimed to know exactly what Hinckley was, or was not, thinking at the moment he pulled the trigger. In the trial's aftermath, Congress continued to recognize the value of expert mental health evidence. So, for example, an expert may still testify that the defendant suffered from some diagnosable illness or syndrome at the time of the charged act and discuss its symptoms. From testimony like that, a jury might infer that the defendant did not have the requisite mental state to convict. But in Rule 704B, Congress declared that task belonged to the jury alone. And allowing a parade of witnesses to speculate about what did or did not transpire in the head of a particular defendant at a particular moment in the past, did not reflect well on federal judicial proceedings and did not aid the jury. Rule 704B may have been a new addition to the Federal Rules of Evidence, but it reflects a much older tradition. For centuries, courts have grappled with the role expert witnesses should play at trial. For a long stretch, many courts barred experts from offering opinions on so-called ultimate issues like mens rea. The Federal Rules of Evidence are no longer so strict, except in one respect, mens rea. On that particular issue, Congress has concluded that jurors need no help from experts. They are fully capable of drawing reasonable inferences from the facts and deciding whether the defendant acted with the requisite mens rea, and in criminal trials that is their job alone. The government violated that rule in this case. Proceedings began when prosecutors charged Ms. Diaz with importing a controlled substance into this country. At the trial that followed, Ms. Diaz did not dispute that she had transported drugs across the border. The only question concerned her mens rea. If, as the government charged, she transported the drugs knowingly, she faced a potential sentence of up to life in prison. If, however, Ms. Diaz acted with some lesser mens rea, say, negligence, or perhaps innocently, she was entitled to an acquittal. To help prove that Ms. Diaz knowingly imported drugs, the government called to the stand Andrew Flood, one of its own employees, an agent with the Department of Homeland Security. Ms. Diaz had made no admissions to him about her mental state, nor had Agent Flood even interviewed her. Instead, prosecutors called Agent Flood as an expert on the minds of drug couriers. And in response to the government's questions, Agent Flood testified that, in most circumstances, the driver knows they are hired to take the drugs from point A to point B. That was a violation of Rule 704B, plain as day. Just walk through its terms. The government called Agent Flood as an expert witness to address the question whether the defendant did or did not have a mental state that constitutes an element of the crime charged. After all, whether Ms. Diaz acted knowingly was the only question at trial, all that separated her from a conviction. And Agent Flood proceeded to do just as he was asked, offering an opinion about that very question. To be sure, prosecutors thought they had a clever way around the problem. They did not ask Agent Flood to testify explicitly about Ms. Diaz's mental state. Instead, they asked the agent to testify about the mental state of people exactly like Ms. Diaz, drivers bringing drugs into the country. And that, the prosecutors argued, made all the difference. The Ninth Circuit endorsed the government's maneuver, holding that Rule 704B prohibits only testimony about the defendant's mental state, not testimony about the mental state of a class of persons that includes her. Before us, however, even the government disavows the full implications of that reasoning. Now, it concedes, the rule does more than bar an expert from testifying explicitly that the defendant had the mental state required for conviction. The rule also bars an expert from testifying that a class of persons has the legally prescribed mental state when that class includes the defendant. Likewise, the rule bars an expert from opining that a hypothetical person who matches the defendant's description will have the mental state required for conviction. All those opinions, the government now acknowledges, are about the defendant's mental state and cannot be offered consistent with Rule 704B. On this, the court agrees. So what is left? Instead of vacating and remanding the case to the Ninth Circuit to correct its error, the government asks us to affirm its judgment on other grounds. As the government sees it, Agent Flood's opinion was permissible for a different reason than the Ninth Circuit offered. It was permissible, the government says, because it wasn't definitive. So, Yes, an expert cannot testify that all persons in a class that includes the defendant have a culpable mental state. But, the government insists, everything changes when an expert offers only a probabilistic assessment that most such persons do. I cannot see how that gambit begins to solve the government's problem. The rule does not only prohibit an expert from stating a definitive opinion about the defendant's mental state, it prohibits an expert from offering any opinion on the subject. Return, once more, to the rule's terms. It bars an expert from stating an opinion about whether the defendant had a mental state that constitutes an element of the crime charged. The word about means concerning, regarding, with regard to, in reference to, in the matter of. So whether an expert's opinion happens to be definitive or probabilistic makes no difference. An expert may not state any opinion concerning, regarding, or in reference to whether the defendant, while committing a charged criminal act, had the requisite mental state to convict, period. Lest any doubt remain, the rule takes pains to emphasize, those matters are for the trier of fact alone. Consider, too, how the government's present theory collapses into the one it has disavowed. Just imagine if Agent Flood had explicitly addressed Ms. Diaz and said she most likely knew she was carrying drugs. Would that testimony be permissible under Rule 704B? Of course not. Probabilistic though the testimony may be, an expert who says that an individual defendant most likely had the requisite mental state for conviction offers an opinion about her mental state. On that, no dispute exists. So how can it be, as the government insists, that an expert may offer the probabilistic assessment that most people like the defendant know they are carrying drugs? The only difference between the two opinions is that the first addresses the defendant explicitly, the second a class that includes her. All of which returns us to a distinction that the government itself seems to acknowledge the rule does not tolerate. Observe, as well, where today's tiptoeing around the rule promises to lead. The court adopts the government's muddled view that an expert cannot offer a probabilistic opinion about the mental state of the defendant explicitly, but can offer a probabilistic opinion about the mental state of a group that includes the defendant. So what happens next? In this case, Agent Flood said most people in the defendant's shoes have the requisite mens rea. But what if he said that drivers generally know? Or that they almost always know? Or perhaps an expert puts a finer point on it. In my experience, 99% of drug couriers know. When cases like those come to us, likely one of two things will happen. We will draw some as yet unknown line and say an expert's probabilistic testimony went too far. Or we will hold anything goes and eviscerate Rule 704B in the process. Rather than face either of those prospects, how much easier it would be to follow where the rule's text leads. The government's approach, adopted by the court today, is no more necessary than it is appropriate. Yes, proving a defendant's mental state at trial can require work. Normally, it will require the government to resort to circumstantial evidence and inference. After all, defendants in life do not confess their inner thoughts on the stand nearly as often as they do in courtroom dramas. But there is nothing new about any of that. Nor is it any secret that the government has a long track record of success in proving mens rea the old-fashioned way by presenting circumstantial evidence and appealing to reasonable inferences. This case illustrates how it can be, and regularly is, done. To persuade the jury that Ms. Diaz knew about the drugs, the government could point to the amounts involved, 54 pounds of drugs worth over $360,000. It could also point to the holes in her story. She claimed the car was her boyfriend's, but then said she had met him only 3 times tops, did not know his phone number, and did not know where he lived. The government could point out, too, that when cell phones were found in the car, Ms. Diaz maintained one of them belonged to a friend, someone she would rather not identify. As well, the government could highlight her statement that the phone was locked and she did not have access to it. And the government could then ask a jury to infer from all these facts that Ms. Diaz knew exactly what she was doing. As it argues to us, the government was free to argue to a jury, asking it to conclude that Ms. Diaz's story was transparently flimsy. Day in and day out, the government secures convictions for the knowing importation of drugs in just this way. There was no need to gild the lily by calling to the stand an expert in mind reading. And there is certainly no cause for this court to sanction the practice. To the contrary, there are sound reasons why Rule 704B operates as it does. The problem of junk science in the courtroom is real and well documented. And perhaps no science is more junky than mental telepathy. After Hinckley's trial, Congress recognized as much when it adopted Rule 704B to remove from federal courtrooms experts who claimed to know what was inside a man's head at a particular moment in the past when he committed a particular act. The particular nook of the criminal law we find ourselves in today illustrates the soundness of Congress's approach. Not long ago, the government tried, often successfully, to put experts, really, like Agent Flood, its own law enforcement agents, on the stand to testify that all couriers know when they are carrying drugs. Not only was that testimony improper under the government's own current understanding of Rule 704B, Eventually, the government felt it had to backtrack after being confronted with too much evidence that some couriers simply have no idea they are being used to carry drugs. So now, the government puts on witnesses to say most couriers know. We cannot be certain how many individuals sit in federal prison because of the government's past impermissible and mistaken expert testimony that all couriers know when they are carrying drugs. About the only thing we can be sure of is that what is good for the goose is good for the gander, and that, thanks to the court's opinion today, defendants will now recruit their own warring experts, ones who will seek to testify, not unlike Agent Flood, that, in their experience, most drug couriers are kept in the dark by cartels. None of this serves our criminal justice system well. A criminal conviction is the gravest condemnation we as a society permit ourselves to make. Allowing into our proceedings speculative guesswork about a defendant's state of mind diminishes the seriousness due them. It risks the reliability of the outcomes they produce. Just ask those convicted in cases where government experts opine that all couriers know. It undermines our historic commitment that mens rea is a necessary component of every serious crime by turning the inquiry into a defendant's mental state from an exacting one guided by hard facts and reasonable inferences into a competing game of I say so. It diminishes our respect for the presumptively free person, his free will and individuality, by encouraging the lazy assumption that he thinks like most. And it reduces the vital role juries are meant to play in criminal trials. Yes, they can still decide whether the defendant thinks like most people. But that role hardly matches Rule 704B's promise that matters of mens rea at trial belong to the jury alone. In describing what I see as some of the possible consequences of the government's approach adopted by the court today, I do not mean to suggest they are inevitable. Today's decision may go a long way toward hollowing out Rule 704B, but it does not address what any other rule of evidence may have to say about cases like this one. And, looking briefly to some of those other rules, I see reason for hope. Take a few examples. Under Rule 402, any evidence presented at trial must be relevant, meaning it must have a tendency to make, more or less probable a fact, of consequence in determining the action. Yet, if the government is right that an expert opinion about the mental state of most people like the defendant is not about the defendant's mental state, it is hard to see how that opinion might be relevant. After all, the fact of consequence in cases like Ms. Diaz's is whether the defendant possessed the requisite mens rea, and it's hard to see how the government can have it both ways. Asserting in one breath that opinions like Agent Flood's are not about whether the defendant possessed the requisite mental state to convict, while insisting in the next breath that those opinions are relevant to, or, one might say, about the defendant's mental state. Thanks for listening. This podcast is not affiliated with the United States Supreme Court or its staff in any way. The summary of this opinion given in the introduction was taken from the summary provided at oyez.org. Any mistakes in the opinion you just heard should be attributed to this podcast. If you would like to support my efforts to make Supreme Court opinions available to the public, please subscribe. Thank you.